Hello, Phil the Engineer back again. In previous blogs I provided the basics of the 4 R's driving healthcare costs: research, regulatory, reimbursement, and risk. Today I would like to examine how the Bayh-Dole Act impacts research and contributes to higher healthcare costs by delaying introduction of new technology into the marketplace. In the spirit of the President's original assertion that we should eliminate those things that are not working, the Bayh-Dole Act should either be on the chopping block or should undergo major rework. In a nutshell, Bayh-Dole allows universities and small business to retain ownership of intellectual property developed with government funding. For a description of the Act, go to Wikipedia and search for Bayh-Dole Act. The original intent of the bill was to foster small business while ensuring that universities were compensated for intellectual property under a grant. One must certainly question what this legislation has to do with healthcare costs. The bottom line is that it essentially establishes a competitive and thus adversarial relationship between universities and business in the negotiation of royalties. Since industry and not universities bring products to market, these negotiations slow the introduction of new products into the marketplace. In addition, it requires that universities have or outsource a legal team that negotiates royalties. This costs money, but of course the argument is, in theory, that this money will be recovered through royalties when the product goes to market. There are at least 2 problems with this scenario. The first relates to the major cost-risk area in product development, which is commercialization. A large investment is required to meet regulatory requirements, and there is no guarantee that the product will be approved. The second relates to the motivation of researchers in the academic community, where the free flow of information is required in order to publish results in a timely manner. Failure to publish results will be viewed as a negative when applying for follow-on grants. Another factor is the turnover of graduate students who conduct most of the research. Intellectual property is constantly going out the door as students matriculate. Since the population of foreign nationals in advanced engineering and science programs continues to increase, in many cases this IP transfers to other countries. Well, let's back up and examine the royalty issue. First of all, it has been estimated that the intellectual property of only 3 to 5% of issued patents ever make it into a commercial product. So 95% of the negotiations are for naught. But since you don't know which ones will pan out, all agreements are aggressively negotiated. These negotiations can take over a year to complete, primarily because dragging out negotiations is beneficial to the university when compared to industry, which is driven by development timelines. Since product development risk is in the commercialization and not government-funded research, the university is negotiating royalties while taking no financial risk in the commercialization. The intellectual property is thus encumbered and becomes a poison pill for cooperative development. Although this law applies to all IP regardless of its application, it is especially onerous in the medical product industry, where an investment of tens to hundreds of millions of dollars may be required to meet regulatory requirements. The major risk to investors is that the product could be rejected by the FDA. In addition, since the university has no investment in product development, there is no sense of urgency in the development of an agreement. Therefore, the university can leverage IP ownership agreements by simply delaying the negotiations to get more favorable terms. As an example, when I was conducting a Phase 1 SBIR that had to be completed within a 6-month period, the university insisted that they would own any intellectual property that I developed while I was using their facility. There is also the risk that the Center for Medicaid Services will not assign a reimbursement code that allows profitable sale of the product. This is especially true for products that go through the FDA approval process for new indications. The CMS may consider this product old technology and reimburse it accordingly, while millions have been expended to meet the FDA requirements for a new symptomatic indication. I had this experience with a queuing device that I developed for Parkinson's disease. I abandoned the product because there was no workable business model to justify the investment. Beyond negotiating royalty agreements, there are further costs associated with management of intellectual property, including patent filing and annual patent maintenance fees. Some of these costs might be hidden in administrative fees charged to the grants, but the content has to be generated by the investigator. Thus, research dollars are used to draft white papers for patents, as well as evaluate potential prior art that could apply to the intellectual property. This means less money to explore the basic science, the real intent of the grant. In my experience, the investigators are interested in the science, and they want the academic freedom to pursue the science that interests them. Timely publication of their results is in their academic interest, as well as necessary to obtain future grants. Unlike industry, their research is not product-focused. In fact, many investigators in the medical community would consider writing white papers for patents as a burden. Since the first priority of medical personnel is their patients, intellectual property development is low on their priority list. As such, timely development of intellectual property documentation to support patents is a slow process. But this is at odds with the timely publication of the results, which can contain intellectual property. Patent filings must be in place before information can be released. If profitability is the investigator's goal rather than academic freedom, they will eventually start their own business or go to work for a medical company anyway. It is easier to obtain investment funds from both investors and companies if the research is directed towards a product. In many cases, these funds may be secured through a PowerPoint presentation. This is in contrast to government grants that require proposal and are subject to the grant process that can seem fickle and arbitrary at times and takes months for review and award. In reality, commercialization of a medical product requires either a large company or investors with deep pockets. Compliance with regulatory requirements drives high-dollar front-end investment with as much as 5 to 10 years before return on that investment will be realized. Investors want to see company staff that has successfully commercialized product. They do not want to see encumbered intellectual property owned by a partner that has a minimal financial investment in the commercialization or no sense of urgency in negotiating any royalty agreements. We must also consider the reality about patents. Patents essentially give you the right to go to court and defend your claim. Legal fees in the millions of dollars can easily accumulate should the patent be challenged in court. So how do we fix this? First, we must fix the incentives for the university. If the timeline for scientific discovery could be predicted with any degree of accuracy, it would be called development and not research. It is therefore virtually impossible with any degree of accuracy to predict the value of intellectual property in the research phase. Yet a Phase 2 SBIR application requires that the royalty agreement be in place prior to application submittal. Development is best done by industry, since industry has the expertise and the marketing and support infrastructure to bring the product to market and support it after the sale. I propose that rather than have the university retain intellectual property rights, that the government should retain those rights. A sponsor, small business or large corporation will monitor the research and manage the intellectual property for the government. Filing for patents is appropriate. The role of the industry sponsor is to focus on commercialization of the derived research. The companies would have visibility into foreign nationals performing the research and ensure that patents are filed in their countries of origin. This will eliminate the negotiation of intellectual property ownership and royalty issues and better protect the intellectual property in a global marketplace. To facilitate participation in a small business, a startup small business will be eligible for a mentor-protege type of arrangement similar to that in DoD, whereby the small business will be paid by the government to prepare documentation for regulatory approval, mentored by the large corporation. The incentive for the university would be an award fee type of arrangement, whereby the university or the investigator, or both, would receive a fee from the government when the industry partner successfully commercializes intellectual property derived from a research grant. The size of the award fee will be based on a schedule derived from product revenue. The fees paid to the university will be recovered through corporate taxes. This approach would facilitate a more cooperative development between university and industry. Companies would benefit through timely introduction of products to the marketplace, realizing a quicker return on investment. Universities would be able to eliminate the cost of IP management and royalty negotiation, applying all the grant funds to medical research. This could be substantial given that 95% of those negotiations are for naught. Overall, this approach would help get new technology out of the labs and into the hands of practitioners. Thanks for your time.